In this lecture, we're going to be looking at the LGBTQ culture in the United States. The reason why I include this group as a cultural group is because it's one of the groups today that still does not have constitutional protected. We have many areas that are constitutionally protected, but this group is not. For example, some constitutionally protected classes include race, color, religion, national origin, age, with the Age Discriminant Employment Act of 1967, meaning anybody over 40, sex, pregnancy, citizenship, familial status and disability status, veteran status, and genetic information. However, sexual orientation is still not a constitutionally protected class. And so that's what we are going to look at in this group, in this lecture, I'm sorry. In fact, in 2015, there were actually 32 states where you could still be fired because you were LGBT. And so what we're going to look at a little bit of the history of the movement. We're going to talk about some of the past cases and recent cases, and then we'll conclude briefly talking about one of the readings I have you doing this week, Go Carolina from David Sedaris. So here's a little background on the LGBTQ culture. And this is actually, if you want to read about this, these are pages 457 to 462 in your People's History of the Supreme Court. But before 1969, members of the LGBTQ community rarely protested their mistreatment publicly. Why? This was due to fear of mistreatment and exposure to the police. Exposure could cost them their jobs, families. Remember, this is not a constitutionally protected class. However, on June 29, 1969, the New York City Police Department raided a gay bar in Greenwich Village, and the patrons refused to leave, and this led to 3 days of bloody fighting, which is now known as the Stonewall Riots. This is seen as the moment that sparked the gay liberation movement. What happens now is we now see fighting against discrimination in jobs and housings, and to have criminal sodomy laws repealed. Many of these laws, when they were enforced, they had very long-term prison sentences. For example, in Georgia, the maximum penalty was 20 years in prison. In 1961, all 50 states had outlawed sodomy, which is, quote, any sexual act involving the sex organs of one person in the mouth or anus of another, unquote. However, studies showed that over 80% of all couples engaged in sodomy, but police hardly ever charged straight couples with the crime. So this was a law that was put on the books and mainly only followed through for those in the LGBTQ community. By 1975, half of the states had repealed their anti-sodomy laws, but none of those were below the Mason-Dixon line, which is Pennsylvania, West Virginia. So now some of these older cases that we're going to look at. The first is Bowers v. Hardwick in 1986. And this law, again, challenges Georgia's sodomy law. And this started in 1982 in Atlanta, Georgia. And there was a police officer, Officer Torek, who was known for busting homosexuals. Torek entered Hardwick's house in Atlanta, Georgia, and found him engaged in oral sex, which is a violation of the sodomy law. He arrested him and his partner. The ACLU had been looking for a defendant who wanted to challenge the law, and Hardwick agreed to become that person because he was sick and tired of being harassed for being gay, as he says. And now you have to remember, this was a very brave thing to do. He faced a possibility of 20 years in jail if he lost. When the district attorney heard of the ACLU's interest in the case, he dropped the sodomy charge. However, the ACLU filed suit in federal court against the Georgia Attorney General, claiming the law was unconstitutional under the 14th Amendment Due Process Clause. A federal judge dismissed the suit, claiming homosexual sodomy was not protected by the Constitution because it, quote, is obviously no portion of marriage, home, or family life, unquote. The ACLU lawyer, Kathleen Wild, appealed the decision to the federal appellate court, where they waited for 2 years. The appellate court judge then held in Hardwick's favor, claiming that private consensual sexual behavior among adults was protected from punishment. Georgia appealed this decision to the United States Supreme Court. This was the first time the court had ever agreed to hear a case dealing with homosexual rights. Georgia's Attorney General Bowers claimed that homosexual sodomy leads to other deviant practices such as sadomasochism, group orgies, or transvestism, to only name a few. Well, what happened? The American Psychological Association submitted a brief stating that, again, 80% of all married couples had engaged in sodomy, and 95% of American males, both gay and straight, had engaged in oral sex, which was a violation of the sodomy law. The case was heard on March 31st, 1986, and the question before the court was whether or not there was a fundamental right under the Constitution of the United States to engage in consensual, private homosexual conduct. Georgia claimed the right to privacy did not extend this far. No married couple had ever been prosecuted under the law, and Hobbs, the lawyer for Bowers, claimed it was unconstitutional as applied to married couples. He also stated that if the court extended the right to privacy, they would be creating, quote, a constitutional right which is little more than one of self-gratification and indulgence. And by furthering this right to privacy, the court would be opening a Pandora's box, which would lead to attacks on laws forbidding polygamy, homosexuality, same-sex marriage, consensual incest, prostitution, fornication, adultery, and possibly even personal possession in private of illegal drugs. He also stated that Georgia was simply adhering to centuries-old traditions and the conventional majority of its people. Hardwick's lawyer, Tribe, stated the case was about Georgia's power to dictate how every adult, married or unmarried, in every bedroom in Georgia will behave in the closest and most intimate personal association with another adult. On June 30th, 1986, the court ruled 5-4 with Georgia. Justice Byron Wright wrote for the majority, claiming the court sided with what a majority of the electorate in Georgia believed, and they believe that homosexual sodomy is immoral and unacceptable. Chief Justice Burger stated in his concurring opinion, quote, to hold sodomy as somehow protected as a fundamental right would be to cast aside a millennia of moral teaching. Justice Blackmun wrote for the 4 dissenting justices and claimed the majority was hiding their homophobia behind the mask of history. He stated only the most willful blindness could obscure the fact that sexual intimacy is central to healthy relationships of all kinds. Blackmun deplored whites' reliance on the ancient roots of hostility towards homosexuals as justification for the modern-day sodomy laws. He concluded that he hoped the court would reconsider, and he said that depriving individuals of the right to choose for themselves how to conduct their intimate relationships poses a far greater threat to the values most deeply rooted in our nation's history than tolerance of nonconformity could ever do. He said, because I think the court today betrays these values, I dissent. 4 years later, Justice Lewis Powell told a law school class that he probably made a mistake in that one when referring to the Bowers case. And remember, this had been a 5-4 decision. If Powell had gotten it right, as he claimed he didn't, the court would have gone the other way. Well, 17 years after Bowers v. Hardwick, the Supreme Court directly overruled its decision in Lawrence v. Texas in 2003 and held that anti-sodomy laws are unconstitutional. And in overruling Bowers v. Hardwick, the court stated that Bowers was not correct when it was decided, and it is not correct still today. And you can see here I have a map that shows you the U.S. sodomy laws by the year when they were finally repealed or struck down. In any of the states that were red, it was not until 2003 that these laws, when they were deemed unconstitutional, were removed. All right, and now we're going to look at the Boy Scouts of America v. Dale in 2000. What happened is we have James Dale, who was a college student in New Jersey. He had been a Boy Scout since he was 12, and he applied for a Scoutmaster position and was accepted. He publicly admitted he was gay, and shortly thereafter, the Boy Scouts of America revoked his membership based on his sexual orientation. Dale then sued the Boy Scouts of America. Now, the Boy Scouts is a private organization, but it's generally open to the public. They accept just about everyone. These groups are usually treated differently, and many states have passed laws banning discrimination based on sexual orientation. The Boy Scouts claim the New Jersey law was unconstitutional, that the law could not dictate who the Boy Scouts had to allow in their private club. And again, sexual orientation was and still is not a constitutionally protected class. The Boy Scouts won at the trial court level. Dale appealed to the New Jersey Supreme Court, and then he won, and the Boy Scouts of America appealed to the United States Supreme Court. And so this is what we're looking at. We're looking at this idea of this freedom not to associate. In the past, the Supreme Court had ruled that certain types of otherwise open-door associations do have a right to restrict membership in certain circumstances. For example, the NAACP does not have to allow members of the Ku Klux Klan into their organization. Why? Because those ideals go directly against what the group promotes. So, again, how they allowed this is under the First Amendment, freedom to associate. This also implies there is a freedom to not associate. And these are what we call expressive associations, meaning associations that promote certain values or points of view, like an association that promotes good citizenship or the importance of buying American-made goods. Well, groups such as these could be compromised if the Supreme Court made them accept members who stood in direct opposition to what they stood for. So again, the NAACP does not have to allow Ku Klux Klan members to have membership. Now, there are limits, and the reasons for not associating must be directly related to the group's purpose. For example, when the JCs, an organization, tried to keep women out, that was rejected. Why? Because it didn't have anything to do with the core foundations of the JCs. So who won in this case? The Boy Scouts did. The court claimed the Boy Scouts sought to transfer faith-based values, such as those in the Scout Oath and the Scout Law, from adult members to youth members. The Boy Scouts claimed, with no supporting evidence and only on the views of the organization and leaders, that homosexuals were not role models consistent with these precepts. The idea was if Dale became a scoutmaster, the entire organization would be forced to endorse a point of view with which it did not agree. So did the Boy Scouts promote any values pertaining to sexual orientation? No. However, the Boy Scouts' view was that merely being a homosexual was inconsistent with morality, meaning if you are a homosexual, you could therefore not be a moral, straight, or clean individual. Rehnquist, writing for the court, claimed the court was not endorsing or agreeing with the Boy Scouts of America, only that the law required this decision. And that, however, the problem with this is that it made it look very clear that the court was taking an anti-homosexual position. In his dissenting opinion, Justice Souter claimed the decision made the right of expressive association an easy trump of any anti-discrimination law. The Boy Scouts case stands for the proposition that organizations whose members focus on and promote a certain set of beliefs have the sacred First Amendment right to define their own membership rules, even if those rules violate anti-discrimination laws. He said the case defines and endorses the constitutional right of such associations to engage in otherwise unlawful discrimination, whether based on race, religion, nationality, or any other protected characteristics. On the one hand, the Boy Scouts' decision manifests a respect for personal freedom uncovered by government dictates. But, on the other hand, it creates a substantial loophole in the legal framework through which the law has, for decades, attempted to implement its non-discriminating ideals. So what happens? Now we have to wait and see what the court is going to do with this loophole. And that is what we're going to look at in the more recent cases. And so what we have is U.S. v. Windsor of 2017, which looked at DOMA, which was the Defense of Marriage Act. Okay? So again, some history. 1986, Bowers v. Hardwick, the court upheld the validity of anti-sodomy laws. In 1993, the Hawaiian Supreme Court finds laws excluding same-sex marriage unconstitutional. However, in 1996, Hawaii ruled same-sex couples were entitled to marry. This begins a wave of laws and amendments banning same-sex marriage. So what happened in 2013 and 2015 with U.S. v. Windsor is the court finally decides to hear the cases about same-sex marriage. So Congress passed the Defense of Marriage Act. The Defense of Marriage Act was a federal law only recognizing marriage as between one man and one woman. So basically it denied same-sex marriage. So what happens is that we have the cases that begin to challenge it. U.S. v. Windsor, and then Oberfeld versus Hodges, which was Ohio, Tanco versus Hounsome, case from Tennessee. We also have case from Michigan, and then Bork versus Bashir, which was from Kentucky. And so what happens in these cases is there were two questions of law before the court. First was, does the 14th Amendment require a state to license a marriage between two people of the same sex? The second one was, does the 14th Amendment require a state to recognize a marriage between two people of the same sex when their marriages was lawfully licensed and performed out of state? Because what we have with Windsor, when we had the Defense of Marriage Act was struck down as unconstitutional, you then had individual states starting passing laws, because marriage is something that is typically done state by state. And so you started to see more and more states allowing same-sex marriage. Well, what happens in the 2015 cases that you see listed here, there's two different things. So first, it was either citizens suing the state they live in to allow same-sex marriage, or it was citizens who had, say you were a citizen of Kentucky who did not allow same-sex marriage. You and your partner went to Vermont that allowed it. You legally were married in Vermont. Now, when you came back to Kentucky, did Kentucky have to recognize the marriage between the people that took place in the other states? And that's what happens in the Oberfeld v. Hodges cases. And so what happens in this is it's a landmark Supreme Court case in which the court ruled 5-4 that a fundamental right to marry is guaranteed to same-sex couples, both by the Due Process Clause and the Equal Protection Clause of the 14th Amendment. So what this case does is it overrules the Baker v. Nelson decision in 1971 that said there is no right to same-sex marriage. So what happens when this ruling came out is basically it recognized same-sex marriage across the United States. One of the questions people often ask is, well, why did they do it at this time? Well, they did it at the time because it was right. At the time of the decision, 36 states and the District of Columbia and Guam had already issued marriage license to same-sex couples. So what had been previously in past decades seen as almost a taboo topic and publicly unacceptable, you now have a majority of the states where the population by vote have voted to allow same-sex marriage. And so what the court basically shows is that, the time is right, that the United States is willing and is going to recognize the right to same-sex marriage, or the right to marriage of all individuals. Okay, well then the last thing I'm going to have you look at is David Sedaris's Go Carolina. This is from Me Talk Pretty One Day published in 2000. Me Talk Pretty One Day is a best-selling collection of essays by the American humorist David Sedaris. The book is separated into two parts. The first consists of essays about his life before he moved to Normandy, France, including his upbringing in suburban Raleigh, North Carolina, his time working odd jobs in New York City, and a visit to New York from a childhood friend and her rather bumpkinish girlfriend. The second section, or deux, tells of Sedaris' move to Normandy with his partner Hugh, and it often draws humor from his efforts to live in France without speaking French, and his frustrations with this. Prior to publication, several of the essays were read by the author on public radio, international programs, This American Life. So what happens, what we're going to look at is the first short story, which is called Go Carolina. And this is where he's talking about his encounter with a school speech therapist. And what the speech therapist was attempting to do was to cure Sedaris's lisp. However, Sedaris found it curious that though there were other students who were equally humiliated by being called out for class for this special training, right, that they all seem to have some common similarities. And you're going to see, basically, he talks about it, that the ones who talked funny were the homosexuals, and they were pointed out for this. So I want you to pay particular attention to how his own teacher talks to him, how the speech therapist talks to him, and what this impression of him speaking incorrectly, what that tells him about himself, right? That it tells him that there's something fundamentally wrong and incorrect with him. And it's called Go Carolina. Why? Because he makes a point early on about boys who don't like sports and judgments that are automatically made. So I want you to keep those things in mind as you are reading this, and think about what this fundamental, he's saying that they're trying to correct his lisp, but is that really what's going on? Are they trying to correct his lisp, or is there something else about him that is trying to be corrected?